All right. I just got a message from my colleague that we are live. So hello, everyone. It's a big pleasure to be here with you and to have such interesting guests and such interesting discussion as we have. I really don't want to take too much of time for this debate. My name is Nicolas and I'm running the PRCP in Prague. And this particular topic came on our agenda last December when we already knew that we will be accepting Nicolas as one of our junior researchers in PRCP, and we were discussing all the topics she has been working on and she's been interested in. And this, she captivated our whole crew for like 30 minutes by telling her stories from the field, and we were all fascinated. And I felt that this is something that we should discuss with more people than just us. It would be a pity if others wouldn't get this this experience and hear some of the interesting stories on how you can apply what you learn at Czech University. So the topic is really fascinating for me. I don't know much about it myself, so I'm really looking forward to learning something new. And I will leave the introductions themselves to my colleague Barbara, who is here together with Tomáš and Nicola on behalf of our International Law Department or International Law Center, who are doing amazing job at our research center, and I'm really excited about these activities that are somehow in the intersection of security studies, international relations, and international law. So I hope this is just one of many events that will be in this area. So welcome everyone, thank you so much, and I'm looking forward to an interesting debate.
Thank you, Michal, for the introduction. My name is Barbara, and now I'm going to set the framework for our discussion by providing some introduction to the ECCC. So this abbreviation stands for the Extraordinary Chambers in the Courts of Cambodia. It is a special Cambodian court which tries senior representatives of the Khmer Rouge regime for international crimes committed during its reign over Cambodia. The regime took power on 17 April 1975 and was overthrown 4 years later on 6 January 1979. During that time, cities were emptied and the population was placed in forced labor camps, and those perceived to be loyal to the former regime were executed. At least 1.7 million people are believed to have died from executions, torture, forced labor, and starvation. The end of the Khmer Rouge period was followed by a civil war, which ultimately ended in 1998 when the Khmer Rouge political and military structures were dismantled. Shortly before the end of the war in 1997, the government requested the United Nations to assist in establishing a trial to prosecute the senior leaders of the Khmer Rouge. Cambodia invited international participation due to the weakness of the Cambodian legal system and the international nature of the crimes. In 2001, the Cambodian National Assembly passed a law to create the ECCC to try the international crimes committed during the Khmer Rouge regime between 1975 and 1979, including crimes against humanity, war crimes, and genocide. An agreement with the UN on the details of international participation and assistance in proceedings before the ECCC was ultimately reached in June 2003. The court itself became operational in 2007. The ECCC combines Cambodian and international judges, prosecutors and defense lawyers, and applies both Cambodian and international law. As a result of this arrangement, it is considered a hybrid court. Another particularity in comparison with other international and hybrid war crimes tribunals, such as the International Criminal Tribunal for the former Yugoslavia, is that the ECCC is located in Cambodia. This allows the people of Cambodia who were affected by the Khmer Rouge regime and its aftermath to participate in the trials and seek justice. The ECCC has also important benefits for the development of the substantive international criminal law, as will be further discussed in our debate. However, despite such contribution to the legal scholarship, the ECCC is also subject to criticism. The critics suspect that the domestic personnel at the court may be corrupted and hence fail to observe impartiality in the process. The current government is seen as having a rather negative stance towards the court and is allegedly taking actions to obstruct the investigations and trials or otherwise undermine its functioning. It is also alleged that some of the members of the current government have been involved or are otherwise connected to the former regime and may be protecting the potential perpetrators. Other difficulties relate to the court's financing. The court is financed through voluntary contributions, which are at times insufficient to cover the operation of the court. The critics also point out to the ineffectiveness in the operation of the court. Indeed, this ineffectiveness may be reflected in the court's caseload. Up to date, so for 14 years of operation, the caseload only includes 4 cases. So the cases are identified numerically as case 1, 2, 3, and 4. Some of the cases have been later severed into multiple case files. Case 1 was completed in February 2012. Case 2 was severed into case 2/1 and 2/2. The first one was completed in November 2016. The trial in case 2/2 is ongoing. It is currently at the trial stage. In this case, the former head of the regime has been convicted of genocide to life imprisonment. An appeal has been lodged against the decision to the Supreme Court chamber. Just to be noted that the same person was also sentenced to life imprisonment in a separate part of the case for crimes against humanity. The cases 3 and 4 are at the judicial investigation stage, where the appeals were lodged against the closing orders by co-investigating judges. And the indictment allegations include genocide, crimes against humanity, grave breaches of the Geneva Conventions of 1949, and violations of the Cambodian Penal Code, namely for homicide. The decision on the appeals against the co-investigating judges' closing orders in case 3 is expected to be rendered tomorrow on 7th April 2021. So we hope that our debate would provide you enough background so we can all better understand what was going on in that case. And now I will hand over the word to my colleague Thomas, who will provide some introductory information about the speakers and about the organization of the debate.
Thank you very much, Vara, for passing the word. It is my privilege to introduce the speakers and the guests of our debate. Before I do it, I would like to remind you that you have the possibility to ask questions through Facebook. You may use the event page on Facebook to ask questions, and we will make sure to pick the best of them and ask them directly to Sangeeta and Nicolas. Also on the web page on Facebook, on the page of the event, you will find full biographies of Sangeeta and Nicolas. However, I will introduce them briefly so that you know whom we'll be talking with today. I would like to start with Sangeeta Yogendran. She's a specialist in human rights and humanitarian law and a PhD fellow at the Human Rights Center, University of Kent. Hi, Sangeeta, welcome. She also participates in ERC-funded project, Writing Victims' Participation in Transnational Justice. In Cambodia, she assisted with the representation of minority groups of survivors. So she was at the damaged party, to say. Apart from this experience, she also worked with the Ministry of Foreign Affairs in Singapore, and she also worked at the International Criminal Court Very interesting thing. She also spent some time in the occupied Palestinian territories, dealing with humanitarian law violations, and she participated in other very exciting projects. You will definitely hear about some of them later on in the debate. And now I would like to introduce our second guest, who is Nicola Kurková-Klímová. She's a PhD candidate at the Faculty of Law, Charles University, and at the same time, she's also a member of our Peace Research Center Prague. She specializes in international economic law, together with international criminal law and international human rights law. At the ECCC, she worked at the Office of the International Co-Prosecutor. She assisted with drafting of an indictment in case 4 that Bara talked about earlier. Apart from this experience, Nicola also worked with the Czech Ministry of Foreign Affairs or Czech Ministry of Industry and Trade, and she worked also for a Czech embassy in London. And I would also use this opportunity to ask first question to Nicola, and I would like to ask her what in her opinion, or what in your opinion, to talk directly, Nicola, was the biggest difference or the most unique thing which makes ECCC special in comparison with other criminal law bodies and tribunals?
Thank you, Tomáš, for your introduction. This is actually a great question at the very beginning, but I feel there could be so much to talk about for the entire hour. So, well, if I were to pick like one or two things, for me, it's definitely kind of like the process of creation of ECCC. Because if you compare it with, for instance, the ICTY or ICTR, so the tribunals for former Yugoslavia and for Rwanda, these tribunals were basically created at the time when the conflict was ongoing, or like immediately shortly afterwards. But the specific case of ECCC is that it took really 30 years from the time when the crimes were actually committed before the court was really established. So I think that's kind of like a miracle, and I see it kind of as a huge commitment to bringing the perpetrators to accountability. And to really fulfilling the goals of international criminal justice. So I would say that this is kind of like one of the very few things that should be highlighted with respect to the court. And maybe the other thing is, I feel that Cambodia is very much an active participant in the work of the ECCC and its activities. So again, if you compare it with the ICTY or ICTR, these tribunals were kind of like, let's say, imposed by the UN Security Council, whereas the ECCC, as we've heard from Barbara, is a hybrid tribunal. So it means that there are not only prosecutors, judges, or even civil party lawyers from the Cambodian side, but also from the international side. So there's kind of like the mixture of personnel, and plus the seat of the tribunal is definitely something that is very beneficial for the fact that really the victims can see what's happening at the court and they can participate.
Thank you. And what about you, Sangeeta? What would you add to this list of uniqueness of ECCC?
Thanks, Tomáš, for the introduction, and thanks for having me for this really interesting discussion. And obviously, I agree with everything Nicola just said, but I think if I had to pick one, and I might sound a bit biased because it's also the topic of my PhD research, but I think what makes the ECCC so unique and special is actually the participation of victims in the process. So traditionally, you have victims who participate in other tribunals as victims or witnesses. So the role is fairly limited to being that of, telling their story. Now, the ECCC actually kind of, went against that pattern and gave victims, at least on paper, full rights as equal parties to the whole proceeding. So you have 3 parties in the courtroom. You have the prosecution, you have the defense, and then you also have the victims as representing themselves and through their legal representatives, of course. So I think that was a very innovative feature of the ECCC, and it's something that's constantly written about and talked about when it comes to these discussions, because it's been, it's such an innovative thing and hasn't really been done before. Obviously, though, you have the reality of trying to have trial proceedings in this international criminal institution, but you also have a situation where you have thousands of, well, hundreds of thousands, arguably millions of victims from Cambodia, and thousands who applied to be civil parties and were admitted to be part of this process. So there's also a very realistic counter argument as to how you would include, up to 4,000 civil parties in case 2, for example, as equal parts and equal parties to the trial. So I think that's something that's played out in a really interesting way for the ECCC. You've seen that kind of change and evolve as the tribunal has gone from case 1 to case 2. We'll have to wait and see how that might potentially change again for case 3 and 4. And also as a result of this, you also have a reparation scheme with the ECCC. And I think that is also something that's very unique. It's not the only tribunal that's had a reparation scheme. The International Criminal Court, notably, is one of the forefront institutions in this regard. But I think the reparations mandate of the ECCC might actually contribute to some of the longer lasting legacy in the country and of the institution. And I think that would be something that's interesting to delve into further.
Thank you. You mentioned victim participation, and you also mentioned that this victim participation was a part of your research, and I guess that this has been also part of your focus during your stay in Cambodia. So please, could you tell us a little bit more about the tasks that you did for the ECCC? Exactly what was your daily routine and the tasks that you did there?
So I have to go more than 10 years back in history without giving away anyone's age, but I was first an intern at the ECCC in 2009, so it's actually more than 10 years now. I was there at the victims unit. It's now called the victim support section. I was there at the victims unit in early 2009, and the section had just been established and set up in late 2008. It was operational and running. So that's something already very interesting that the ECCC started. And then a couple of years later, you had the victims unit begin its work itself. So I was one of 4 interns. We were among the pioneer batches of interns for that unit. So the good thing about that is we were heavily involved in all aspects of the unit's work. This included, legal research on collective participation and reparations. It included, coming up with a budget for how to keep the office sustained and going throughout the years, which fortunately it did. Working together with the staff to bring civil parties and victims to the tribunal when case 1 first started. And that's something that has always remained with me as a very memorable experience, because we brought all 90-something admitted civil parties from case 1 to the tribunal for the start of the trial. And that was also the time when the accused, Doik, actually made an apology. He turned to the audience in the tribunal and made an apology for the crimes he had committed. So that was a very particularly interesting day, sitting among victims and civil parties as they were listening to, someone that had harmed them or their family members or even killed them apologize for the crimes he had committed. So I can definitely tell you I didn't have 2 days of the same in the victims unit. And I think I really enjoyed that process. After the internship, I actually stayed on in Cambodia and started working with one of the civil party lawyers directly and part of the legal team to come up with submissions for until that point, unrepresented minority group, which Nicolas and I actually have some similarities to share about that particular group and how it's affected case 4. But for me, that was interesting because I went from an intern within the court structure to now working outside the court structure, but very much, engaging with it. So that gave me a whole new perspective, because through that experience, we got to actually go out and talk to people directly, ask them about their experiences and their victimization, which was not an easy process, compile legal submissions to represent this group, and then try and advocate the court to include them in a case that hadn't, yet been created. So that became case 4. So for me, that internship started off as such a, enriching experience and grew and became so much more. And I'm very lucky and fortunate to be able to now do the same research on victim participation at the ECCC for my PhD. So I'm very thankful for those circumstances coming together.
It's great to hear about your experience from the side of victim participation, and also great to hear you about case number 4, because this gives me the opportunity to ask Nicola, who worked on case number 4 and who, in comparison to you, took the perspective of prosecution. So Nicola, could you also tell us a bit more about your tasks that you did during your work for ECCC?
Sure. This event actually shows how the world is really small, because when we were looking for another guest, Sangeeta actually applied, and then we just realized that we basically work on the same case, just on different sides of the case for different procedural parties. So that is something which is very interesting, and it's great actually that we can meet at least here virtually. So I was an intern at the International Co-Prosecutor's Office, so as you've heard, in 2018, so a few years ago. As you've heard, the ECCC is a hybrid court, so the prosecutor is actually composed of kind of like 2 subunits, one of the national prosecutor and the national Cambodian staff, and international prosecutor or co-prosecutor and the international staff that is hired by the UN. So I was sent as a UN intern to Phnom Penh, and really didn't know what to expect, because that was my first practical experience with international criminal law, but I was very much looking forward to that. So at the time when I arrived in Phnom Penh, the prosecutor, the international prosecutor, was very busy, the office, with several things in parallel. So there were several outstanding procedural issues in case 2/2, because that was shortly after the trial hearings, and there were still, like, the summary judgment was kind of like being awaited at that time. And then there was case 3, where the prosecutor was drafting the final summary, so which is kind of like a document where they are when the prosecutor summarizes their findings after the investigation phase, and they're kind of like suggesting whether there should be an indictment and whether the case should be sent really to trial or not. So that was case 3, but I wasn't assigned to any of these. I was assigned actually to case 4, and specifically to a very small team, which was driven by a wonderful supervisor of mine, and I'm so thankful that I could work with her. And we were actually dealing with the final summary for the prosecution of Yim Thith. So one of the accused who is still awaiting the trial, and we'll see whether the case will go to the trial, because case 4 is still in the pre-trial stage. It was very much when I was in Cambodia at the office, and basically what I was first asked to do was to help with some procedural decisions and drafting, but then I was assigned one very specific task, and that was the analysis of 2 legal issues. One of them was the sexual violence crimes, which were committed in Cambodia, and that is something which is very specific about the trials as well, and about the caseload of the court. And the other thing was the genocide and persecution of Khmer Rouge minority, ethnic minority, and this is exactly the touching point between me and Sangeeta. Because I don't remember really the story that you told me like perfectly, but I think that there was your colleague was pushing actually for the prosecution of the crimes against and like involving the persecution of this ethnic minority. Well, it was me who actually was handling at some points in time the caseload and the analysis of the evidence. So basically, my daily work consisted of reading lots of witness statements, basically witness statements, but also some documentary evidence if that was also available. Working on a database, but you can't really imagine anything very much sophisticated. We really worked like from the scratch with Excel spreadsheets, and we started from there, and like really working my way through all these witness statements to identify the specific crime sites, to identify the specific crimes against these specific the members of this specific minority. So that was very much my work, and then I after like a month or 2 months of this analysis, I was able to start drafting some sections naturally with the consultations of my supervisors. So that was pretty much the part of work which I did at the ECCC.
Thank you very much. And Nicolas, what was the most challenging part of this work? Was it this administration and bureaucracy during the first 2 months of just going through the cases and identifying the possibility of crimes, or was it a kind of a new environment, or was it something else, please?
Well, I wouldn't say really bureaucracy or administration, because like the analysis of the evidence is something which is like the necessary prerequisite for drafting any final summary for the case. So it's kind of like, I would say, the core of the work of the prosecutor's office. Let's say that. But there was something which was very specific about the work which I did. I mean, before I joined the ECCC, I already had worked before in a law firm on huge international arbitration cases. So I was kind of like used to lots of evidence, you know, like hundreds of thousands of pages, but in a language which I could understand, because that was usually English or Spanish or French or something which I could like easily grasp. But what I just didn't expect in Cambodia and at the court was like the immense amount of the witness statements, which were really taken by the co-investigating judges and their units. So that was a huge work, and also the civil party lawyers, because I assumed that there were lots of submissions from their side as well in the case file. But this is something which I didn't expect, because lots of, like, they did amazing job. There were so many testimonies which we could work on, but the thing was, they were actually taken in Khmer. That is not the language which you can easily master in a few months. So we had to rely very heavily on a wonderful group of translators who assisted us. But there were also interns, Cambodian interns at the prosecutor's office, who were very helpful. Luckily, they managed to teach me a few crucial terms, so I could read very simple words in Khmer, like just to identify the crime site or some very specific terms which I needed to identify. And then I had to really go and bother them again and ask them for the explanation and for a quick translation. But to be fair, the translation of documents from Khmer to English takes very long. It's very complicated. So basically, what I think they told me, like, it takes about three pages per day. So it's really complicated to get the translations done. So that was something what I had to kind of like get used to at the beginning of the work. And then, as I said, the team which I joined was very small. It was basically me, another intern, and our supervisor. Because like the rest of the international co-prosecutor's office was just focusing on some other aspects of other cases. So at the beginning, there were just 3 of us who were basically working on some of the aspects of case 4 against Yimtith. And to be fair, these case files or the cases which are prosecuted at the ECCC, it's not something that you can easily translate into or compare with the cases that are being litigated before domestic courts or prosecuted before domestic courts. It's just like these crimes really count hundreds, thousands, even millions of victims. The crime sites across the entire country. So really, the amount of evidence which is needed for the review and the preparation of the final summary is just immense. So doing that job with 3 people was something that really surprised me. But after I left, the rest of the international co-prosecutor's office, they joined the case 4 team, and they managed to do a great job with really finalizing this document. Yeah, well, I guess that's pretty much it.
Thank you. You mentioned a large amount of witness statements and also large amount of victims and their statements, which gets me back to Sangeeta. And I would like to ask her the same question. What was the biggest challenge for you? Was it a similar amount of statements of people you had to talk to, get together and get to the court? Or was it the emotions that you had to feel when you sit among the victims when the accused apologized, or was it something else, please?
Thanks. I think it's such an interesting question, because I think you hit the nail on the head for my answer, at least, that a lot of it was the emotions of it. And I think because I was very, much younger and much more naive about the world, I only really took the time to process a lot of this after I left Cambodia and was, doing something completely different by that point. So two things, right? First, during the internship itself, it was just overwhelming because, again, like Nicolas said, for the victims unit at that time, it had just started up. It had this huge mandate on its hands. There were a few people, they were actively recruiting more staff. So a lot more colleagues joined during the time I was there. You had to train staff to be able to not only, analyze these civil party applications and these victim testimonies, but also train them on, how to manage the psychosocial effects of going through so much of this material and so much of this data, which is just very heavy and grim, and you're hearing the worst of the worst. So I think that was just very overwhelming for someone who was new to this work, new to this field, new to the country. I mean, don't get me wrong, I loved everything about the country, and I never felt that it was an adjustment being there, but the work was just overwhelming. There were a lot of emotions involved. Like you said, that one day that we were sitting in the courtroom, I was sitting next to some civil parties who were, who kept asking to get assistance because they were having headaches or stomach aches, and, having to escort them out to the sick bay in the courtroom, only later realizing, having spoken to some of the NGO support staff, that they were showing clear classic signs of PTSD. So, these were all very eye-opening experiences. So even though the work was overwhelming, it was very, very rewarding. I think seeing it from that perspective made me really believe in the power of the International Criminal Institution and how important it is to have victims involved. And then, of course, the second element is when I was part of the civil party legal team putting together the submissions, which ironically is what Nicola would have been going through, and all those victim and witness testimonies. A lot of that would have probably come from our team that we started compiling years ago, literally going out into certain provinces, asking to speak to people who were willing to speak to us about these traumatic things that happened to them, taking down testimonial, again, having someone translate on the spot because, Khmer, none of us were fluent in it. We depended so much on NGO staff and local translators to help us, putting together submissions from scratch, making sure that all the crime sites were aligned so that, you could build a case for it. I mean, that was a huge task, and no wonder it took years and years, of which I was just a part of. But it was also very rewarding, even though it came years later, to know that that then became part of case 4, and that, what we had put together actually had some value and substance. Whether it goes to trial or not is another issue, but I would like to think hopefully having that recognition was, important for the people that we were trying to get justice for.
Thank you. Very, very interesting answers from both of you. And Sangeeta, how did your previous work experience or study experience help you to overcome those challenges, this overwhelming amount of work? And more generally, how this helped you to get to the ECCC, please?
I'll admit, I actually think it was the other way around, because I think for me, at least my first internship was so early on. I think instead of having had a lot of experience until that point to prepare me for that, it actually was those experiences in Cambodia that then prepared me for everything else that came after that. So I think if I may, I'll actually just reverse the question, because that experience and being able to work so closely with victims of mass human rights violations actually then prepared me in all the work I did after that. So for example, being able to work with refugee communities, being in Palestine and working with communities there facing daily violations of humanitarian law, for example, I think if I think back and acknowledge it, it was Cambodia that then prepared me for everything else to come. I think it was purely a case of timing as well, because it was one of my first internships and then one of my first work experiences after that. And I think going into it, I may have been a bit too naive, if I'll admit. I don't think I was nearly prepared. I hadn't had any formal work experience yet. I later worked in a law firm and then, was able to go, okay, going through all this documentation and all this evidence is actually very much part of the legal process. For me, it was the other way around as to what Nicola just described. And I think it was so formative for me in the sense that after that, it gave me a lot of perspective. Even when work was then very demanding after that, it actually didn't seem as demanding as being in Cambodia at that time, trying to surmount these huge tasks. And I think what was very real for me from that experience was you're doing it for, you're not doing it for yourself. You're not doing it for the institution. You're doing it on behalf of victims that you hope will get some sort of healing or justice from this process. You are merely a part of this whole process. But I think that has carried through with me. So I would say I wasn't prepared going in, but it actually gave me a lot of wonderful experience that has then helped me with my career and personal life since. And I think it gave me a lot of empathy, I would say, in speaking directly to people affected by these situations that are just so beyond what we can imagine. And I would like to hope that that's an empathy I've carried through with me in my work even till today.
Very nice answer. Thank you so much for this. And the same question for Nicolas. What did help you? You already mentioned that you were used to going through large amounts of documentation, but what else helped you to get through, to succeed in front of ECCC? And what did you learn there and take away home, and to other places that you visited? What did you take there from Cambodia?
Well, for me, like getting to the ECCC was a bit of coincidence actually, because at the time when I was back in 2018, I was still at law school, and I was still thinking about like doing some internships in the field. So before that, I did work on the UPR human rights review system at the UN for the Ministry of Foreign Affairs. So I was very much interested in and lots of the questions and lots of the reviews of countries which I helped to work on were also related to serious human rights violations. So at that time, I was also attending a class on international criminal law, and I was thinking, well, it's a great area of law. It was just like from the perspective of substantive and procedural law, just legally, it sounded very interesting, and I was just like thinking about what it must be like to be either a prosecutor or even a member of the defense team, for instance, or judge in just deciding over these cases. And then I was just like reading through a blog article, and I just like flipped over the author's affiliation, and I realized it's my friend. And she was at that time actually interning at the ECCC. So I was like, what a great idea. So I texted her, I asked her for her like experience with the ECCC. And she was very enthusiastic. She was also interning for the International Co-Prosecutor's Office. So we talked a lot about exactly how the work can be very challenging, but at the same time, exactly as Sangeeta said, very rewarding in the sense that you feel you're contributing to some, if not really transitional justice, then at least the legal sense of the justice for the horrific crimes that are being prosecuted by these courts. So I just look at the website of the ECCC, and luckily there was still opening for the internship. So I did apply on the very last day of the deadline. Shame on me for that. But I just like sent all the materials, and I was like, okay, I'm never going to hear from them back. But then I did a few weeks later with an invitation to an interview. So I was very surprised, because that was really, as I said, my very first experience with international criminal justice. And to be fair, ever since this internship, I've actually stayed in the field very much, not only in academic terms, but also legally. So I did help on some cases in my legal practice, which were related to some international criminal, either defense or like cases which are being right now discussed before some international courts, and I'm sworn by confidentiality, so unfortunately I can't really disclose very much. But yes, so from that on, I've actually stayed very much in the field. I did lots of research on related topics which were which are touching upon the things that I worked on during my stay at the ECCC. So in particular, the sexual violence crimes and kind of like the sites which were either discussed but still couldn't get in through in the final summary of the international prosecutor, especially the gender perspective on sexual violence crimes. Because what is very specific also about the ECCC is that as a lawyer, you can't really prosecute people using the law and applying the rules which are enforced right now. There is the principle which is called nullum crimen sine lege, which means you have to apply the rules which were applicable and existed at the time when the crimes were committed. And right now we're talking about like not the times that like 1990s when the international criminal justice and the substantive criminal law was in the bloom, just because of the ad hoc tribunals. But the thing is, it was back into 1970s. So we had to very much look into the customary international law and see what were the crimes which were defined there at that time. And to be fair, with the sexual violence crimes, it was very specific because there was no definition of rape as a crime against humanity, for instance. And there were so many instances of this horrific crime in Cambodia. So we had to figure out the ways how we can actually prosecute this crime under different headings, such as other inhuman acts and forced marriage, which was also another related act to the rape side. So this is something which was kind of like omitted. Also, the gender perspective on the sexual violence against men and boys. That is something which was also discussed at the ECCC because it was very relevant to the crimes that were prosecuted there. But the thing is, again, back in 1970s, the definitions of the crimes were actually not very gender neutral, let's say. So they didn't, unfortunately, enable us to do lots of the work that we wished to do in terms of the prosecutions and bringing perpetrators to accountability. This is changing quite a lot, and we have recently actually seen one of these very huge leaps in the jurisprudence with the recent judgment in the Dominic Ongwen case at the ICC. So there was the question really of the gender perspective on sexual violence crimes. So that was something which really stayed with me, both kind of like academically, but also professionally. So I have to thank to the ECCC for bringing me to this field.
Thank you. Before we stop for the questions that are already coming through the Facebook, I would like to ask one last question. Nicolas, you mentioned slight challenges or fascinating issues connected with gender perspective or retroactivity that you had to deal with. I would like to ask about another challenge that ECCC faced. It was often criticized for certain selectivity of cases. Do you think that this selectivity of cases can be reconciled with the commitment of international community to punish those who perpetrate crimes, those serious international crimes under international law?
Well, that's a very good question. And I think you can have actually different perspectives on that. Like, if you take it by definition, international criminal law as a project is kind of like selective. And we have heard about the selectiveness a lot with respect to the ICC, and especially the type of situations that the ICC is investigating. Also how the law and politics are interacting in this field. So by nature, international criminal justice is very selective. But at the same time, I can't really say, and I wouldn't subscribe for the opinion that the selectiveness is necessarily the bad thing. Because to be fair, international criminal tribunals and courts, they do have necessarily limited capacities, both financially, but also personally. They do not have any enforcement power. So there is no police, for the ICC, or there was no police for the ICTY, ICTR, who could just go to a completely different country, because all these courts are relocated typically, and then just like try to detain people who are being accused of the crimes that are within the jurisdiction of these courts. So by nature, there is selectivity which is due to these kind of like limited capacities of the courts. Plus, I think personally that the international criminal courts and tribunals are not the only players in the field. As I said, like lots of these courts historically were really relocated from the crime sites or from the countries where the crimes were committed. They did not really involve the victims participating in the proceedings, which I think is an important aspect of international criminal justice, especially with respect to the transitional justice. So it is even, I think it is desirable that national courts also take part in the pursuit of the goals of international criminal law and bringing accountability for the most horrific crimes. And there are luckily concepts which enable that. So let's say universal jurisdiction, which is quite widely used right now. But there is also the principle of complementarity, which is also discussed with respect to the ICC. So the national courts kind of like should have the primacy over the prosecution of the crimes, and only if there is either unwillingness or inability of these kind of like national courts to deal with the situation, which can be either political, but also, you know, lots of the countries just emerged from long-term civil wars. So naturally, the justice system is just not ready for complex cases. Then the international criminal courts and tribunals can give their hand. But so that's where the selectiveness for me comes from. Well, for ECCC, of course, the debate is a bit also different. It's not just about just the selectivity, which is kind of like defined by the personal jurisdiction. So the ECCC can prosecute just the senior leaders of the Khmer Rouge regime or the people who are most responsible. So this is kind of like a peculiar definition of the perpetrators or people who can be prosecuted and fall within the jurisdiction of the court. But there's also the criticism of the politicization and on the selection of the cases. And I think we will touch upon that again and again in our next answers. But this is exactly the reason why cases 3 and 4 are so difficult to get to the trial stage, and where there are lots of discussions and lots of resentment from the Cambodian government to get further prosecutions ongoing. So the selectiveness issue at the ECCC may be a bit more complicated with other aspects.
Thank you. And the same question for Sangeeta. What about you, Sangeeta, and selectivity? How do you feel about this issue?
Thanks. I think, Nicola, you covered so many aspects of at least the context of the ECCC and the nuance there when it comes to selectivity of cases. Maybe I'll just add to that for me, I have two answers here. One, it's from the perspective of myself as a legal practitioner, and two, it's from the perspective of the victims, which I think is what these institutions are supposed to be prioritizing. They are the communities you're supposed to be serving. And I think this question really needs to be answered by the communities they're supposed to be serving. So I would be very interested to know if, for example, if you ask Cambodians how they felt about the selectivity of their cases, whether they thought that was a good thing or a bad thing, or maybe they thought that it was restricting some of the avenues for justice. I agree that there should be avenues above and beyond just that one institution. For example, the reparations program could be one way to focus on community healing without going through a legal process. The national courts could take over some of the other cases. And I think the selectivity is important when you think about it very practically, because at the end of the day, you also want to see the institution, you know, being able to run forward with cases, being able to successfully prosecute them or defend them, whichever is the situation. And, you know, the more you are able to do, given the circumstances you're in, I think is a good thing. But I can imagine that the selectivity, depending on the group of victims you may be speaking to, may not be such a good thing if they're not on the receiving end of that selectivity. For me as a legal professional, obviously, I believe that I would rather see that selectivity in small amounts to be able to see the institution get to do its work than, you know, not have that selectivity, but then maybe doors can't even open for these institutions to set up. For example, Cambodia is a perfect example for this. And Nicola, you touched on this. If you have, you know, not that selectivity, you might see you have already seen some opposition from political parties and the government in having, you know, too many cases and having some cases not try only the senior most leaders. In Cambodia, this is because this will affect a lot of people who are currently in government positions. So, I mean, my personal opinion is that selectivity can be reconciled with international criminal justice if you're able to still go with some very important seminal cases. And in Cambodia, hopefully that's what's happening. Although I think at the end of the day, it's not us that need to answer this question, and it's actually the victims who these institutions should be serving.
Thank you for very inspiring answers. With that, I would like to pass word to Bara, who will ask questions from chat and continue with her interesting set of questions.
Thank you, Thomas. So we are now slightly moving to the ethical and political significance of the ECCC, but before doing that, we got a very interesting question from the chat from Matej Jungwirth. I'm going to quote the question so I don't change the meaning. So the question goes like this. Reading about ICTY, ICTR and ECCC, I just wondered, how do all the professionals on these courts, be they local or international, keep their sanity? Or in other words, how do you keep a necessary professional and legal distance from the testimonies you are reading or hearing, but not become hardened and entirely devoid of empathy for individual victims of genocide, mass killings? I think we already touched upon that issue a bit. So maybe first let me ask Sangeeta what is her view, since she worked with the victims directly.
Thanks, Barbara. And I think it's a really good question, and maybe one that we as professionals in this field don't talk about enough. And I think we should be doing this a lot more. I admit it's very hard to keep your sanity the more and the deeper you dive into this work. I think it does become very personal to you. For me personally, I don't think that's a bad thing, because as long as I still have that empathy and I feel those emotions, I think that's a good sign. I think I get worried the day that I won't empathize and I'm not being affected by some of these stories I'm hearing. That's when I think I've really, lost my connection with this, and I would need to take a step back, and I hope that day never comes. Like I said, I think the first time I went into this, I definitely wasn't prepared. And I think now, with the benefit of hindsight and a lot more training, I understand the need for having, actual professional training when it comes to the kind of work that involves hearing and talking to people who've gone through this horrible stories, and you're hearing it, and there is a lot of that first-hand effect that can have on you. For example, now with the PhD program, we actually spoke up and asked for a training on vicarious trauma so that we would be prepared going in, and for ourselves as researchers and professionals, be able to identify some of the signs when we need to actually, take a step back from the work and acknowledge how it's affecting us emotionally, mentally, physically. And I think that's very important, whether you do it through a professional training or you have a personal system of being able to check in with your loved ones. I think that's what helps you keep your sanity. I was very fortunate being in Cambodia that Singapore, my home, was not that far away. And I was able to travel quite frequently as far as I could. And I know that not everyone had that ability. So I think, even simple things like having the interns go out together at the end of a really long day and kind of just de-stressing, having regular calls and video calls with your family and loved ones back home. These are all things for you as a person in this work to be able to maintain that empathy and not become too hardened, like the question said, but also make sure that you're taking care of yourself. And I did not realize this when I was, in my early 20s doing my first internship. I now realize how important this is, because you can't, it's cliche to say, but you can't help other people. And in this case, you can't help victims and communities if you're not able to take care of yourself first. So I think that's a very good question, and hopefully just having a support system, whatever that means to you, whether that's professional or personal, having that always, I think will really help you stay empathetic to the work and avoid, some of the vicarious trauma that could come about from this work.
Thank you very much, Sangeeta. That's very insightful view from someone who has worked directly with the victims. So let me turn to Nicolas and ask the same question. Does your perspective change a bit when you are on the co-prosecutor side?
Well, I do agree completely with what Sangeeta said. It's so important to have a support system which is in place if you're supposed to deal with such a heavy case. And in my role as a very young intern and dealing with really for several months in a row with the sexual violence crimes that typically ended in mass killings. And victims being really slaughtered and just thrown into mass graves. That was something that I was dealing with every day on a daily basis, reading all of these testimonies the entire day, and then drafting really those sections of the final summary. So at first I was really horrified. I must admit I had few really terrible nights having read the initial testimonies. I just couldn't imagine that some of the victims really they did survive all of these horrific crimes, and they were still able to testify. I just couldn't imagine the trauma that they were going through every time that they had to share their story. So that was something which I really did acknowledge from the very beginning of my work. Later on, I can't say it's not a thing that you can get used to, but it's really the way that you get deeper into the witness testimonies. You still feel lots of empathy, but at the same time, I think what helped me quite a lot to like rationalize and analyze the witness testimonies and get the legal job done, it was also like the sense of responsibility that I felt. It was me who was really like just going through these witness testimonies and trying to get the core of them to build the case, which would be strong enough to persuade the judges and start the trial. So I felt the responsibility for like getting my job well done to ensure that the victims get what they deserve, which is being heard at the trial stage effectively, and getting the crimes really being examined by the judges. I think that was something which kept me going quite a lot, and it still does. So again, as Sangeeta said, I hope there will never be a day when I just don't feel the connection and that sense of responsibility. So but it is really something, it is an immense burden that the people at these international courts, be it the prosecutors or the defense office or the civil party lawyers, they have to deal with that.
Thank you very much for this personal view. So Nicolas, you mentioned that maybe a sense of providing justice to the victims is very, very important. This brings us to another question that appeared in the chat. It was posed by Ataur Rahman. I'll quote the question as it relates to the whole context of the international criminal justice. So what's implementing challenges you're looking in context of international criminal justice?
Okay, I'll go first. Just briefly. So I think the international criminal justice as the system right now is really going through quite an intense debate on the legitimacy, which is really related not only to the selectiveness but also to kind of like the functioning of the courts, which are necessarily very expensive. And still many feel that these courts do not deliver. And at the same time, there is new research still ongoing, but there have been several academic articles already published on this topic, is how really the legal justice and these legal prosecutions really help to kind of like reconcile the society and help the victims to heal. So especially in cases where, you know, as I said, these international courts, they do have limited capacity. So sometimes the cases which are built are not that strong as the prosecutor initially thought. There are acquittals of people who stand the trial. And, you know, if there is the acquittal, then there is the question, okay, what about the victims? You know, if there is the acquittal, the victims just can't claim the reparations at these courts like the ICC. At the same time, there is the sense that the victims know that the crimes were committed, they went through them, but, you know, the person who was just like at the trial, he's just walking free. So, you know, kind of like trying to reconcile also that part of how the international criminal justice in the legal sense can really can relate effectively to the transitional justice. I think that is one of the biggest challenges that is ahead for this field.
Thank you very much, Nico, for the answer. Let me turn to Sangeeta. What do you think about the ECCC in the context of international criminal justice and related challenges?
I think, and maybe this applies to not just the ECCC, but international criminal justice as a whole, is the, I dare say the word, interference of politics. I think it touches a lot about the legitimacy that you spoke about, Nicolas. And I think, you know, if it's always going to be subject to the nuances of international politics, then you start having people question the legitimacy of international criminal justice. For example, if you need UN Security Council resolution for it to pass, but then you have certain members that can block that from happening, for example, you don't necessarily see a mechanism being set up. So I think one of the biggest challenges for not just the ECCC, but, you know, all these similar institutions is just being able to continue with their work and maybe take on new cases or even set up new institutions without political interference. I realize that's, you know, a lot easier said than done. And we saw this play out in Cambodia, where even though the ECCC was set up, there was a limit to how much it could take on because of political interference. Even the argument about cases 3 and 4 was a very political one, and it was a debate, and it made the news because, you know, certain people in government had threatened that the country could descend back into civil war if you took on too many cases. And now that's something that can be very scary for a country to hear after having been through such a traumatic past in the first place. So, you know, I think to all the current debates in international criminal justice now, and wonder how political interferences will shape what mechanisms may or may not come out of this. Immediately, I'm thinking of Syria and Myanmar, for example, which, after a lot of wrangling and a lot of political blocking on the UN side, have now both established independent investigative mechanisms. So not a tribunal, but an investigative mechanism that can collect and consolidate and analyze evidence if ever there is a case brought. So, you know, it's very interesting to see how it's a good thing that you have two independent mechanisms being set up for Myanmar and Syria. Whether this will ever turn into a case before the International Criminal Court or the ICJ, or a independent mechanism and tribunal set up, we'll have to wait and see. But I think the political interference right now might be the biggest challenge to the legitimacy of the field.
Thank you very much, Sangeeta. You actually just answered one of the questions I wanted to ask you. That is about how is the work of the ECCC affected by the political situation in Cambodia. So you mentioned that there might be government interferences maybe as a result of the fact that some of the members of the current government were somehow linked to the former regime. Let me ask the same question to Nicolas. What do you think about the political situation and its effect on the ECCC?
Well, as an intern who worked on case 4, there is actually quite a lot to say, because case 4 has been such a troubled case in terms of the pre-trial stage. Well, cases 3 and 4 in general are kind of like waged against people, accused persons who are not really the most senior leaders, let's say, but they were kind of like mid-ranking. So there is the question whether these people could fall within the scope of those people who are most responsible for the crimes committed during the Khmer Rouge regime. But from the very beginning of both of these cases, basically, there has been quite a strict opposition from the current government, from the Prime Minister Hun Sen, who repeatedly basically declared that these cases were not, going to the trial stage, and besides case 1 and 2, there will be no further cases. So the pretrial stage, and especially the investigation of in case 3 and case 4, was very much influenced by kind of like these debates about whether the cases should even go forward, whether the ECCC should not even, terminate its activities and just like go and leave. At least the international staff from the UN. So from my own experience, when I was at the prosecutor's office, there was still investigation ongoing, but that was at the time when the co-investigating judges were still very much in conflict with each other in terms of really the personal jurisdiction. So whether Yim Tit really fell within the personal jurisdiction of the court. So there was a clear opposition from the national side who held the legal view that this person just didn't fall within this definition, as it was in the statute of the ECCC, whereas the international co-investigating judge was very much in favor of kind of like pursuing with the investigation. So there were several kind of like ups and downs, lots of replacements of co-investigating judges, especially on the international side. There were repeated allegations actually of political interference. There were also allegations of political interference from the international co-prosecutor when we asked for the reopening of the first ones. So there were several closing orders actually for the investigation, and several attempts to reopen the case file again for further investigation, because the prosecutor still felt that there wasn't enough evidence, on the case file to kind of like to make the indictment, to make the final summary, and to send the case to the trial stage. So they were still pushing for more and more investigation, especially for the fieldwork, and bringing more witness testimonies on the board. But the thing was that even the international co-prosecutor at once also faced threats of penalties and sanctions if they really pushed for the reopening of the investigative phase. So cases 3 and 4, in summary, really troubled cases. There was a huge disagreement, which was, I think personally, kind of like waged under the rhetoric of law, but personally, I can't really say whether this wasn't more about like the political side of the cases, which I think is much more probable. Right now, once the closing orders were filed, we can see that the political situation again is still very complicated. The national side, the national co-investigating judge, so their office pushed for the closing and terminating the case 3 and 4. The international co-investigating judge has an opposite opinion, so they really want to push for the trial stage. Again, there is a huge disagreement. Tomorrow we will see how the case 3 will unfold, which can actually, I would say, set the tone also for case 4. So I'm very much looking forward to reading the decision on the appeal by the pretrial chamber. And we'll see how they will deal with the fact that there are 2 co-investigating judges who have conflicting views on whether a case is serious enough to go to the trial stage. But well, as I said, if this doesn't happen and case 3 is kind of like sealed and archived, I personally don't think that politically there will be much will to pursue with the investigation or prosecution on the national level. So I feel that this will be basically the end of the prosecutions of the crimes from the Khmer Rouge era. So we'll see.
And actually, if I can just quickly add to that, I think what's really interesting is that cases 3 and 4 have also started admitting civil parties for quite a while now. So you have victims who have been registered and approved as civil parties who may or may not ever get to see their case go to trial. And I think that's something that's really significant because you have victim participation, but how much of it? You know, you have a very short amount in the sense that they've applied, they've been approved, they're part of the process, but then the process itself, it might be cut short. So I think that's an interesting element to consider, that victims might have a lot of expectations about finally being included in these cases and how they might feel if at the end of the day, these cases never go to trial.
Well, at the same time, there were several statements, even from the national co-prosecutor to the victims, that they shouldn't expect any case 3 or 4 just going forward. So it's really an open debate, and the role of politics can't be really denied in any of these prosecutions and investigations.
Thank you very much. And in view of those political interferences, Nicolas, you already touched upon the future of the ECCC that you don't see very brightly, actually. So do you think there would some more cases are going to come up, or is it going to end with number 4 and then it will be dissolved? Or for a like person, what can we expect from the future operations of the ECCC?
So legally, I feel, as I worked on case 4, I really hope that it goes to the trial stage, because I feel there is such a strong evidence on lots of the crimes that still really merit a deeper discussion, such as the genocide of Khmer Rouge or the sexual violence crimes, including the forced marriages and the subsequent rape, which was the forced consummation of the marriages. But as I said, like, the situation is as it is. Plus, to be fair, in cases 3 and 4, there are 2 conflicting closing orders. There are 2 cross appeals. So the international co-prosecutor appealed against the national co-investigating judge's closing order, and vice versa for the international co-prosecutor against the national co-investigating judge. So these cross appeals are kind of like complicated, and we have seen that actually in case 4/2 of Aoan, where the exact same situation was happening. So there were 2 conflicting closing orders, 2 co-investigating judges, one saying, okay, this case is going to the trial stage, the other one, okay, this case should be sealed and archived. Prosecutors also divided on this question. And to be fair, any decision making at the ECCC is very complicated, just because of the so-called supermajority rule. So all these chambers, like the pre-trial chamber or the trial chamber, they're composed of the national and international judges. And the national, the Cambodian judges have the majority of 3. The international judges, there are 2 seats for them. And to have any decision, you have to reach a supermajority, which means 4 votes. And now at the stage when you have 2 conflicting closing orders, 2 conflicting appeals, it's basically impossible, and it is very much expected that even the judges will be split very much on the national and international side. So what I fear that might happen with cases 3 and 4 is basically that there will be no supermajority for either the closing or the trial stage. And at that point, we are in a legal limbo, like you can't move there and back. And when case 4/2 hit this ground, what happened was that the case was really sealed and archived. So if we reach really this stage of disagreement and this conflict of legal opinions, I fear that this might be the situation with cases 3 and 4, but I still very much, as I said, hope that legally the cases are strong enough to go to the trial stage. Well, if my pessimistic opinion just really wins and gets into reality, I don't know if there will be further prosecutions really before the national courts. And to be fair, I really don't know if the victims would be really willing to participate in national proceedings. So that is maybe the question to you, Sangeeta, because you have had lots of discussions surely about this aspect.
Thanks, Nicola. I think you're right. I want to be optimistic about this, but realistically, I do not know if this, both cases 3 and 4 and the split cases within them will not just end up getting sealed and archived, which is why I think what is promising about the ECCC and where the legacy lies is actually in the reparations regime. You've got some very promising reparations orders from, well, more so case 2 than case 1. As you know, in case 1, the reparations order was just a compilation and publication of all the civil parties and the names and the publication of the apology of the accused. But in case 2, you had a lot of wonderful suggestions for reparations, most of which were approved by the court to have, public education materials, remembrance occasions, memorials being constructed, the provision of services that would, help people, whether through schools, through the provision of psychosocial care. All these things are very promising to see the ECC's legacy through, even if no more cases go to trial. What's interesting, of course, about the reparations regime from the last reparations orders from the last case is that they were approved, but even before they were approved, it was made very clear that the victim support section, the civil party co-lead lawyer's office, and NGOs need to go and find funding for these reparations on their own. They're not going to come from the accused persons because all of them did not have the money and resources, which in itself is very unlike international criminal law. You are supposed to fund reparations orders from the assets and income of the accused person, which was not an option in Cambodia. So in order to get these orders through, the ECCC was quite innovative by telling the concerned officers and departments, go find the funding for these reparations ideas already, have a plan in place, which would have involved so much work, as you can imagine, not only coming up with a reparations idea, but finding the resources and finances to fund it. And then at the end of case 002/2, when the judges were actually making a decision on it, all the plans were already in place. So whatever was approved can now actually go ahead. And I think the collective nature of the reparations might actually lead to a lot more people being hopefully positively affected by the reparations than a few more extra cases might get to be able to do in the ECCC's context. I would love to see more cases personally and legally as well, having put in all the time and effort from the perspective of one legal team into one of the submissions, of which there are now so many. But I think practically speaking, there's a lot of political, there's no political willpower for this to continue. But I think what could be a really interesting and important contribution is seeing some of these public memorials, education projects, psychosocial services that will reach a far wider audience. And maybe that should be where the continued legacy of the ECCC can focus, even if the actual legal institution of it cannot continue.
Thank you very much for this view. This actually brings me to a question that is more ethical and inquiring about your point of view, whether when considering all such difficulties and troubles that are linked with getting the justice done at ECCC, do you think is it worth prosecuting international crimes that happen such a long period of time before the ECCC proceedings are taking place? Is justice delayed really justice denied? Let me ask Sangeeta. Yeah.
Yes, if you want me to respond, I'll respond first because Nicola took the first one the last time. I think that's actually one of the questions I'm hoping to be able to answer with my research if I have the opportunity to go to Cambodia, to be able to ask victims and civil parties directly, has this actually made a difference in your life after more than 40 years now since the actual end of the Khmer Rouge regime? Would you have actually preferred being able to continue with your day-to-day life? Has the process of participation actually helped you? Does it help you now, more than 40 years later, to have to rehash a lot of this, traumatic memory from your past? it's, I think, a very important question to ask, obviously from a personal perspective and being, you know, passionate about this area of law, especially. I would like to think that justice delayed will always be justice denied. And even though a long time has passed, it's still very important to account for the crimes that took place. I think Cambodia is a place where it's so beautiful and, you know, people are so friendly, but if you just dig a little under the surface, there are obviously a lot of scars that this has left on a whole generation of people. And I think it's really important to acknowledge that and account for it. I specifically remember a lot of stories from Cambodian friends who would tell me that either their parents or their grandparents never really talked about this. You know, it's not something you spoke about as a family or over the dinner table, for example. I heard stories of some grandparents who, if they did talk about it, grandchildren often, you know, reacted with just complete shock and surprise and disbelief that these things even happened in their country because it was so long ago. You now have a majority of people in the country who were born after the end of the regime. So they have no collective history or remembrance of what happened. So I think you need to not only acknowledge that there is that remembrance that needs to happen, but therefore also that accountability, because I hope it never happens, but, you know, there's always a risk of history repeating itself. And I think if you don't have that accountability and that message out there that, you know, you cannot get away with committing such horrific crimes, there will be repercussions. Even if you as an accused person are in your late 80s, you know, Cambodia has seen quite a few accused people pass away within the time of the trials taking place. But I think it's a very important message to send. And I think in the Cambodian case, it's led to a lot of public education around what happened and what we can do about it and how we can heal as communities. A lot of NGOs have done dialogues between older generation folks and, you know, some of the youth to have that intergenerational dialogue as well, so that people know what happened, and that it's actually talked about a lot more. So I think for me personally, as long as justice is delayed indefinitely, it will always be denied.
Thank you, Sangeeta. Let me turn to Nicola and ask the same question. Do you think is it worth prosecuting international crimes after such a long period of time?
Well, as Sangeeta said, I still do believe that even though it's delayed, it's not really worth just discarding the accountability for what happened in the past. And for ECCC, we should take into account the very specific context of the country. So until like 1998, there was civil war, so there was no chance that any international criminal court or tribunal could be established in the country to prosecute the crime. So that is a very specific context, and that was also something which also kind of like complicated the work, because for lots of the international criminal tribunals, I do have friends who worked at the ICTY, and they had the chance to use other evidence for prosecutions apart from witness testimonies of victims, you know, which were taking like 30 years, if not more, from the crimes. And that's also one of the weak spots at the trial stage, you know, where you see the defense counsels really tearing apart all these witness statements and saying, okay, this, like, there are inconsistencies in these witness statements. How can you really rely on them to say that there is beyond reasonable doubt a guilt of this person for these crimes? So this is a not only ethical but also legal aspect, which is some with the justice delayed. Also, as I said, like, I do have the friends at the ICTY who had the chance to use other evidence than the witness testimonies, so they could really go and exhume the bodies of the victims, which was also a heavy part of the ICTY, for instance, or ICTR. This was not really the point of work or the activity, like the major source of evidence for the ECCC, really. So that's why the victims and their participation was really crucial for all these for all the cases which have been are ongoing or are already terminated. But in terms of like justice delayed for the international criminal justice and its goals, let's say that I still do believe that there is more than just the legal aspect of international criminal justice. It's not just the legal sense of accountability, of bringing perpetrators and sentencing them. You know, this is not something which would typically affect the ordinary lives of the victims, I would say. Although if you talk to them, they definitely do feel, you know, a relief, a sense of kind of like really the relief that you know there is some acknowledgement of what happened to them. But I do believe that the outreach activities of the ECCC are something which is really the core of its legacy. I very much hope that the funding will be in place for many of these outreach activities, because there have been very complex remembrance plans of building archives, you know, for the education of Cambodian population about their history, and also of bringing the memory of the victims. But the thing is that the funding is also one crucial aspect that is being very much discussed. Still, the ECCC and also the NGOs which are cooperating with the court are doing an amazing job in this regard. But let's hope that their work will not be really hindered by what's going on in the country. And that everything stays in place as it is. As Sangeeta shared her experience, I also had like several Cambodian friends when I was in Cambodia at the court, and when I really talked to them, they did share really the same stories, that there is not much talk in between the generations in the Cambodian population about what happened. And really the younger generation just was not only shocked, but they just really didn't believe that, you know, there were people from their own nation who did it to their own nation. Just don't forget that it wasn't some external force or external power who was really imposing these very harsh policies on the population. It was Cambodians just committing the crimes on the Cambodian population. So this is something which is even, I think, more difficult to kind of like accept. So I do hope, and I think that from my experience, the ECCC is kind of like contributing to this very painful debate, which brings so hurtful memories. But I feel that this discussion is very much needed.
Thank you very much, both Nicola and Sangeeta, for sharing such experience with us. Since we are a bit running out of time, I would like to hand over the word to Thomas to ask some questions from the chat and provide some closing remarks.
Thank you. For the audience, there is the very last opportunity to ask a question through chat, because I have the last one coming through chat to ask, and if there are no other questions, we'll be heading towards the end. And the last question that we received is coming from Martin Horák, who asks, do you think that the genocide of Uyghur people in Xinjiang will ever be prosecuted? And I'll probably start with Sangeeta and her opinion about that as somebody working with minorities.
Thanks, Thomas, and thanks for that question. I think it's a very needed question, and it's definitely a topic of a lot of discussion right now. Okay, so the difficult part about this is that if it goes through any of the traditional political routes for international accountability, for example, through the UN or through, a UN referral to the International Criminal Court, for example, or a UN mandate to set up a separate mechanism, it is very likely going to be vetoed by China. So I think as much as this is needed, and it's something that, increasingly is being acknowledged in the global community, it is going to have to be tried and prosecuted through one of the means that is not subject to the powers of veto. Whether it's China vetoing it or some of its allies vetoing it, this is a very real concern. One of the possible areas that I'm thinking of, and I'm sure, Nicola, you can add more, is the ICC prosecutors' discretion to suggest potential cases and investigations. I think that is something that might be a realistic way to try this and have the genocide be prosecuted. The it'll be a very interesting discussion to see who will be the subject of the prosecution, because with international criminal law and the International Criminal Court, you can't just have the state. You'll need to have specific individuals responsible for the state. And of course, getting them to appear at the International Criminal Court will be a whole other challenge. But I think starting an investigation into this will send a very strong message, at least from the international community, that this is something that the world sees that is happening. We see more and more evidence coming out of it happening. And that might be in itself a very important acknowledgement. I don't claim to say that it's going to be nearly enough. I don't know if it's going to stop it, but I think it might be important to say, look, we know what's going on, and we're at least going to try and hold some of the people responsible accountable for what is a genocide that's happening right now.
Yeah, I do completely agree. I don't feel the UN mandate and even the route through the Security Council is a viable option for the Uyghur people. So there definitely has to be some alternative way. If it is really the prosecutor using their proprietor powers, that's a question, because there are also debates and criticisms of how politicized this selection really is. And second of all, even the prosecutor's office at the ICC really does consider the prospect of bringing really the accused person to the trial. What is the point of having the trial of a person who just will be tried in absentia? They will not appear, and the judgment basically will never be executed. So I think that another alternative option would be the universal jurisdiction. So really, if there are typically not the highest ranking political leaders, but some mid-ranking or low-ranking leaders, let's say of the camps where Uyghur people are being detained. And if these people appear outside the borders of China, they may face prosecutions by some national courts based on the principle of universal jurisdiction. So because lots of the crimes that Uyghur people are reportedly facing do really fit within the definition of crimes that can be prosecuted in this way by any court, even though there is no personal or territorial link to either to the victim or the perpetrator or the crime site. But the thing is, again, it's really very much dependent on the effectiveness of these domestic prosecutions. So if there are no people, you can start the universal based on universal jurisdiction any cases you wish. But the thing is it really worth doing if you have not the person who should be brought to accountability in place to stand the trial? So there could be the chance to bring some of the people who are involved in the anti-Uyghur policies in China to be brought to justice. But the thing is, there will have to be some very sophisticated cooperation. And these people will have to kind of like get outside the Chinese borders. Otherwise, I don't see that in China, the national judicial system would be really willing to do anything about that. But really, the cooperation side has proved difficult on several instances. The ICC could be talking about that long stories, and especially the story of Omar Bashir, the former Sudanese president, and his travels across the world, and the numerously failed attempts of the ICC to get the cooperation from other countries to get Omar Bashir to The Hague. Yes, that is something which international criminal justice is not really ready for in terms of its effectiveness.
Okay, really greatly put. And we have very last question that is coming from Christoph, who stands today as our technical support, but has very, very good question for you. So Christoph, please ask it directly. I think it's a good idea to ask it directly.
Okay, I'm sorry for do you hear me? Just a quick note. Yeah, I'm sorry for the viewers for absence of my face. I'm without the camera for the technical reasons. Anyways, my question is is coming from the critical spectre rather of the international criminal courts. You both have wonderful education. You are coming from very from the perspective of Cambodian person who was typical a victim of this crime, you are somewhat coming from a society or place in the world which could seem much better. There is often a critique used quite commonly by dictators, but also by some like post-structuralists, post-constructivists, that these kind of issues could be some sort of extension of could you use the word of colonialism, but I don't mean it in a way. How did you personally deal with this? Did you have any feelings like, oh, do I actually belong here to investigate these people? Like, did you feel intrusive or anything like that, or was it like just generally fine? That would be my general question. Thank you very much for your answers in advance.
Okay, I guess I'll go first then. But well, that is a great question and a topic which was bothering me all the time when I was in Cambodia, actually, because necessarily like the project of international criminal justice is kind of like bringing external advisors very often, or external legal staff to a country to which they have little links, I would say very limited knowledge sometimes as well. They do not know well the history. They do not stay long, or they do not stay just so long to get to know really the nation and kind of like the feelings of their towards their history. So I did feel the pressure of being an outsider, getting really into this very difficult materials and just to judge, which of these information is really worth being cited and being highlighted to the judges and yeah, being referred in our legal briefs. So like this selection of information and like my position of deciding what is not really like better but legally more worthy to appear in the legal briefs, that's something that I personally I can't say I've really stopped struggling with this feeling. I still do, but what does help me is to really be very attentive to the language that these witness testimonies were using, to try to really dig deeper into also the cultural, the social, the historical background of the country. So besides like my job at the ECCC, I came home in the evenings and I did really read a lot about the Cambodian history and just to get the grasp of what it felt to live in the regime, what it must have been to go through for the victims, and also talking, of course, to people in Cambodia, and if they really felt naturally talking about that, because you do have to respect the way that sometimes they just do not want to share the story, and they do prefer to bury the past. But if they felt like really opening to me and sharing their experience, then I felt that just getting these even personal testimonies outside the court was something that helped me to be very attentive to the needs and kind of like the wishes of the victims, where they felt the trial should be steered to. So I still try to find the balance between like the legal side and the ethical side in that. But yeah, my solution was kind of like trying to connect more with the society to which this project of international court is supposed to serve.
Thanks, Nicola, and thanks, Christoph, for the question, because it's a great question, and I think it's a really important one, that we acknowledge that there is a lot of, this colonial attitudes, not just in the field of international criminal law and international criminal justice, but in us as professionals trying to work in it, even though I hope most of us have the best of intentions in doing so. And I have to admit, for me, I'm going to answer in a very personal way, because this has, for me, been a balancing act as well. I come from Singapore, which is a lot more economically and in every way a first world country. And yet we're so close to a place like Cambodia that went through this past that, for me, it was shocking that we were so near and yet so far from this. So for me, going in first as an intern and then working, on and off for the next couple of years with victims directly, I was very aware of this balancing act, because on the one hand, I was socially hanging out with the other interns who were predominantly from Western countries. And on the other hand, I felt and I looked, just by the pure default of the color of my skin, looked much more local. So for me, this was a very interesting balance, and one that I tried to make the best of. I was very fortunate that Cambodians as a people are already very warm and welcoming, even more so when I noticed that, once they found out that I was from the region, I was Indian or Hindu, like that's something that everyone found a lot of similarity with. And I think I was very lucky that that helped break down a lot of barriers. And that was still confusing for me, because I felt like sometimes I want to be one of you, but I'm also not, and I can't claim to understand what you've been through. At the same time, I'm also hanging out with a very Western group of colleagues and friends who are also trying to make these very important legal decisions for you and on behalf of you. And that's not something I was ever comfortable with, not something I continue to be comfortable with. It's actually something I'm having to write about now in my PhD, and the methodology and thinking of it, because I am somewhat an insider, but I'm also very much an outsider coming in to do research on victim participation. I am very aware that a lot of transitional justice research can be colonial, in the sense that we're trying to speak on behalf of victims and communities. And in doing this research, even though I'm trying not to do that, I am kind of doing that. So I'm also trying to find that balance. I think I was very fortunate that coming from a place like Singapore gave me that first world Western perspective, but also just by default of being close enough, enabled me to break through a lot of those cultural and social barriers, and enabled me to have very deep conversations and relationships, which I think, not just for the work, but for personal reasons, really shaped my whole life and my career after that. It's something I hope to honor and stay true to. And it's something I hope to represent now in my research as well, because yet again, I'm an Asian scholar, but very much situated in a European institution. So that it's also a personal balance for me to strike in a way that will be most authentic to the people I'm hoping to research and, serve in that process. So thank you for that question. I like that we can acknowledge that there is a very colonial aspect to these conversations and this kind of work, but that we're all aware of it, and we're trying our best to, be as authentic and true and get away from that as we can.
Okay, thank both of you, and also Christoph for wonderful question and wonderful answers that provided us with great cultural reflections. This is great. Yeah, and well, with this, I see that we are already at the end, so I would like to take this last opportunity to thank very much to Sangeeta and Nicolas for joining us, for covering the contributions and challenges of ICCC, and also for being very open about their personal experience that they went through. I would also like to thank everybody in the audience who asked the question or who participated. We really, really appreciate it. And finally, I would like to thank Peace Research Center Prague and Michal for facilitating this debate. For everybody in the audience, there is the possibility to follow the pages of Peace Research Center Prague and learn about future similarly interesting events such as this one surely has been. So thank you once more. Thank you for being us, and have a nice evening.
Thank you, everyone. This was exciting and very interesting. I learned a lot, so thank you, and good luck with your research. I'm sure this will bring you to many interesting corners in the world. Thank you.
Thanks so much for having me. I really enjoyed this conversation and the pre-conversation that we had as well. So, I hope this reaches a lot of people and the people it needs to reach.
Yeah, thank you for hosting the event. I'm so grateful that we could have it, and thank you, Sangeeta, so much, Barbara, for great participation in our debate today. So it was great to have you all here.
Yeah, I really enjoyed myself. So thanks so much, everyone.
You guys have a good evening. Take care.
Yeah, good evening.
Bye.
Bye.
Thanks again.
Good evening.